today's episode, I'm actually having a special guest for a special type of episode about legal agreements and law within your business. Here I have Devin Miller of Miller IP Law. Thanks for coming on to the podcast.
Thanks for having me, Jason. I'm excited to be on.
Awesome. I'm sure a lot of people want to pick your brain when it comes to this stuff because, as I mentioned in a lot of my podcast episodes, legal agreements and certain documentation that you need to start a business is very important. But unfortunately, a lot of entrepreneurs don't have a lot of money to pay lawyers, right? Because, for example, in one of my tech startups years ago, I paid thousands and thousands of dollars to get all the documentation I needed to get up and running. And we did raise some money, but we didn't exit. So that money was kind of lost, right? So we'll start with the basic agreement that you really do need to begin a company is usually an operating agreement. And what do you usually tell people when it comes to starting a business, why they need an operating agreement, why it's important?
Yeah, I mean, I would kind of put the whole business formation, operating agreement is part of it, but a business formation is probably the first step. And, that includes, filing it with the state, getting an EIN number, getting the operating agreement, all of those, I would say, kind of typically bundled together in the sense that you're going to do that all at the same time. The general reason why you're getting operating agreement is a couple-fold. One is to shield you from liability, right? You don't want someone coming and if you do get sued or you get someone that's angry at you, you don't want them to come after your house, your car, your personal savings, your retirement. And so typically if you're a sole proprietorship, you do it just as a DBA or you're doing it as an individual, you leave yourself open to liability. And so what you're trying to do with the business formation is you're trying to shield yourself, at least your personal assets from that. Now, the one follow on to that would be if you're doing an operating agreement, typically if you have more, if it's all you and you own 100%, it's pretty straightforward and simple. If you have partners, you have multiple people that are in the company, operating agreement, typically you set it up for the worst case scenario, right? In the sense that if people get mad, if they die, if you don't get along well, the business doesn't work out, if it goes bankrupt or anything of those type of natures, you want to have lined out how you deal with those. If you have if you give, as an example, let's say you give both people a 50-50 split in the company, right? Seems to make sense. You're both partners, you're both founders. Now, let's say you both have 50%. Does that mean you both have 50% voting rights? And what happens if you have a tie vote? If one person wants to do it and the other one doesn't, how do you deal with it? So that's kind of the things that you're trying to deal with when you do an operating or when you do an LLC form or a business formation, including an operating agreement.
All right. So it's kind of like the Bible. It tells you like everything to do with your company. So you need to look back and see, well, how did we decide we were going to do this? Well, it's in the operating agreement. So it's important to have. You mentioned when you have a company and you have all these people in the company, but a lot of times these people that start businesses, they don't really have an LLC or a C Corp yet or an S Corp yet because, they don't have any money, right? They're just in the concept stage. They're just trying to get off the ground. So like, do they really need all that EIN number, LLC paperwork and like all that stuff if they're still in the beginning stages?
Yeah, I mean, it depends on beginning stages could mean a lot of different things for a lot of different companies, right? If it's just you've got an idea, you're building prototypes, you haven't put it out in the public, you're probably okay with it out without a business yet. In the sense, now I'd usually say once you get ready to introduce it into the public, that's probably at least by then you're going to want to do it. Now, I'll give you the one exception. If you're taking on investor dollars, you're taking on money from other people, you're not just bootstrapping it yourself, I would get it before you take in other people's money other than your own. Absolutely. Because you don't want, if they ever get mad and sue you, they get, let's say that you take in on investor dollars and now they own part of the company, you're going to want it to be own part of the company as opposed to anything individually. But if you're bootstrapping it, doing it yourself, then I would probably say when you're getting ready to either launch it, engage with other people, get contracts in place. Let's say you're going out and getting a manufacturer or you're doing other things that you're putting legal agreements in place. You typically want to have those agreements with the business and the vendor as opposed to with you as an individual. So once you get past just bootstrapping yourself, doing it all yourself, then you're going to want to have that in place.
Awesome. Yeah, that makes a lot of sense. And that's what I tell people too, is that if you're going to start showing the product to people or you're going to take in investment money, so it makes sense. Now there's something else that people always want you to sign, right? When you come into a business or they want to show you a prototype, they say, sign my NDA. Now, I haven't signed an NDA in years because I tell people, look, I get pitched way too many times. So as soon as I sign it, it's already void. But now why do you think people make everyone sign NDAs, and if they're not really going to be protected by them, because technically, from what I understand, NDAs, you can kind of skate around them. But why is it such a big deal? Why do you think people think it's such protection or whatnot?
I mean, if my general rule of thumb is an NDA is better than nothing, meaning if you can get one in place, it's a little bit why not, in the sense that it does give you a level of protection. If somebody were to blatantly just take the information and give them, rip it off, do exactly what you're doing, it does give you some of that protection. But to your point, there are exceptions in an NDA. There's, if you can show that you had the idea before, working on it independently, you bought it from somebody else, there's a lot of exceptions. So NDAs are kind of one of those. Is better than nothing, but don't give it. Too often it gives people a false sense of security that they think, oh, now I'm covered, I can tell them everything. Well, I usually would say get an NDA if you can, doesn't hurt, but really judge who you're working with, because if you have to go to litigation, if you have to enforce it, the best way to avoid problems is to make sure you're working with good people and good parties, and that avoids much more of the problems than trying to get an NDA in place.
Well said. Yeah, I think it sounds more like car insurance. You when you have it, you might have to use it, might not have to use it, but you should have it, right?
Yeah. So I mean, there isn't a drawback to, other than to your point. Now, if you're a lot of times you're an investor, you're somebody of that nature. If you work with a lot of startups, you may not want to have an NDA, because you're saying, hey, to your point, I get pitched 100 ideas a year, and I don't want to box myself out from taking or listening to somebody else's idea because I signed an NDA with you. And so a lot of times, some investors will, but most of them are going to say, hey, I'm not going to sign an NDA. Tell me what you'd like to at your own risk. If you don't want to share the details, then that's fine, but I'm not going to sign an NDA, because they don't want to exclude themselves from a better opportunity down the road.
Yeah, and I think one of the biggest challenges I've noticed from entrepreneurs is they're afraid that if they tell you their idea, you're going to steal it. And I think that they don't understand that just telling somebody your idea, it's just not good enough. There's an idea versus execution stage, right? And executing on an idea takes a year, 2 years, 4 years to do. And, so they think, oh, if I tell you my idea, you're going to run with it. But like, no, because now I have to spend a year to 4 years building your idea. Why would I do that without, it just doesn't make any sense. So I think I always tell people, start giving your idea out to get feedback. Because if you don't do that, then you never know if it's even worth pursuing in the first place. And you're wasting a lot of time signing NDAs and possibly turning people off. Because the truth is, a lot of times people email me, I have an idea I want to pitch to you, but can you please sign an NDA? And I say, sorry, I can't do that, because I might be working on a similar project, or I might have already built something or whatever. So I just don't sign NDAs anymore. This brings me to the next agreement, which is similar, but is one of my favorites, because when I was in one of my first tech startups, I was told I had to do this, and I was afraid, because I was like, wait a minute, I'm signing away all the rights to the IP assignment agreement. And an IP assignment agreement, in the intellectual property assignment agreement, you are signing away the rights to the idea to the LLC or the corporation that you now own, so that you no longer own the idea that you were getting NDA signed for. Now the company that is getting the investment dollars owns the IP. Now, tell me a little bit about why that is so important, and why people should look into, everyone should be signing an IP assignment agreement when they jump into a startup.
Yeah. So, I mean, IP assignment agreement, maybe is to give the general baseline. That's basically, you're saying that while I invented this, the owner of the idea, I'm signing over all my rights to this idea to the corporation, to the business, right? In a sense that now I don't own it personally, it's rather the business. And it can be your own LLC. A lot of times it is, hey, I'm the inventor, but I sign over my rights to the LLC, so the LLC owns it. So a couple of the issues that you get into is if you don't assign it, meaning if you had employees that just all come and work for you, you didn't have that as part of the employment agreement, you didn't have it as what's called the CIAA, which is typically a lot of times agreement, you'll have people, and it's confidentiality and assignment agreement. I always forget what the I stands for. But that one is an agreement that it says basically the employee has a duty to assign over to you all the rights of the invention. And the reason you do that is if you don't, your employees, you may pay them money. You think, oh, I'm paying them. They get a salary. Of course I own it. But in the legal sense, a lot of times you don't own it. Employee leaves the company, goes off, does their own thing, starts their own company, becomes a competitor, goes and works for your competitor. They can take they have the rights of they contributed to the invention. They can do anything they want. They can go sell it to another inventor. They can go do it on their own. And so if you don't have those assigned over, it leaves it for everybody that's an inventor on your invention has equal rights to go do do whatever they want with that invention, including sell it to other people, start on their own. So that's kind of, if you don't have that in place, can create a lot of issues for not having ownership. And then where it even gets worse is, let's say you go out to an investor, you go out to someone and they're going to do, if they're in any sort of a, beyond friends and family, a real investor, they're going to have probably an attorney that looks over your intellectual property, your patents, and they're going to say, well, where's your assignments? Who has the ownership? And they're going to say, well, it's ours. Well, it may be yours, but if you don't own it, then it leaves it open. They're probably going to be a deal killer because they're worried that the other people are going to go sell it off to somebody else. They don't have proprietary. So it can create a lot of issues. And obviously the best way to do that is to avoid it by just having that agreement in place such that the company owns all the inventions that you invest in as opposed to individuals.
Yeah. It's funny. One of the scary parts of doing that too is, everyone has seen, at least most people have seen the movie, The Social Network, right? Where Mark Zuckerberg supposedly steals Facebook from the Winklevoss twins. And, it begs to question, if you do sign over the rights to your business or your idea to a company, and then you get exited from the company, you get fired from the company, or you get, whatever happens from the company, you get booted. Now you don't own the idea anymore because the company does. And this has happened before to lots of people. Like Steve Jobs famously got booted from Apple, right? And so he no longer owned the idea because it's no longer his anymore. So is there any way to protect yourself from, as far as I know, there isn't, but maybe, some kind of loophole that.
No, honest answer is not really. I mean, I would defend the companies for a second, then I'll give you maybe one idea of an exception, which, is an exception. Generally, if the company is paying you to do it, if they're giving you a salary, if you're an employee, they're giving you insurance, they're paying your salary, and you are doing the work they hired you to do, they probably should rightly own it, in the sense that that's what they're paying you for. And if at the end of the day, if now you own all of the things that they paid you for, then it's not fair to the company, because now they paid you all the work. You can take everything they paid you to do, and they're left in the cold. So I think that there is that fair trade-off of, hey, if you're going to go work for them, if you're going to do using their resources, using their facilities, get a payroll, or get a salary, get insurance, and all those things, and you're doing what they hired you to do, they probably rightly should own it.
But what about if you're the founder? Like, what if you're the founder of the business? It's like, say you and two co-founders, it's three people, right? CEO, CTO, and VP of marketing. You guys own the business. Investors come in. They now own 51% of the company after, 3 rounds of funding. And they decide, you know what, we don't want you guys anymore. We want other people now to run the company because you guys aren't really doing a great job. Whereas you might think you are doing a great job. And they can just boot you out. You don't own the business. I mean,
yeah, other than when you make the original agreement with taking on investor dollars, you can sometimes safeguard against that, right? So one is to keep the majority ownership in the business. Don't give up the majority ownership, and therefore they can't boot you. Or don't take on investor dollars. But you're right in the sense that if you take on investor dollars and they own the majority of your company, you now work for them. You're now their employee. They're not your employee. And so you do always want to consider, when you're giving up that, that equity, there's benefits to taking on that equity. Maybe you need it for development. Maybe you need the investment, but it does come with those handcuffs. The only way, if 2 ways to avoid it. One, it wouldn't typically work. You could, one is the woodwork. If you can keep the majority ownership in your business, then that works. You can keep control. If you have to give up control, then the other way to do it is to simply try and make it difficult, put in their clauses to remove you, that, you keep so many people or seats on the board, you keep so much, so many overall, maybe you don't own it, but between you and the 2 other people, you own more than the investors, such that overall you still have the voting rights, something of that nature. Other than that, the only other exception is if, let's say that you working for a company, maybe you're a startup or small business or whatever, and you have a different idea, your next great idea, and you don't want the company to own it. The only way you can get away from that is you don't use any company resources when you're developing that new idea, right? So don't use any of the money that's by the company. You don't use it. Don't do it when you're working at the company. Don't use their computers or their hardware, software, or anything else. Do it at home. Do it on your own. Keep it away from the company. Don't use any of that. And generally, if you want to pursue your next big idea, you don't want the company. You can go down that route. But if it's the company and they own it, it's going to be hard to get around it.
Makes sense. Yeah, and this is why a lot of people aren't really sure what to do, because there's a lot of, these term sheets, the investors, when they hand you a term sheet and it's got, everything favors the investor, right? It doesn't favor you,
Mm-hmm.
because, so a lot of people are afraid to raise money, or they know that they need to try to get as much done as possible on their own. And then there's, like you mentioned, protecting with patents and stuff like that. I mean, there's provisional patents, there's utility patents, there's copyrights, there's trademarks. And people always ask me if they should copyright their idea or trademark their idea or patent it. And my answer, which is a very, simplistic one, is you only want to trademark something if you want to protect like a brand name that you're going to be using in commerce, if you're selling t-shirts or something. And you only get a patent if you have something that you invented that is useful, that has some sort of mechanics to it that somebody might want to try to use in the future. But there's probably a lot more to it than that. And so let's say you're a new business and you have just a mobile app, okay? And you just have a mobile app, and say that you're just about to launch. What would you tell them to do to protect their idea out of the four different things, the copyrights, trademarks, and
so, and I would say that the typical three ways, trade secrets, that's a different animal, and I'd probably for a different conversation, but typically intellectual property includes patents, trademarks, copyrights. And to your point, patents are going to be anything that's an invention, does something, has a functionality, has a utility to it. Trademarks are anything for brand, anything that name of a company, logo, catchphrase, something, name of a product, those type of things. And copyrights are going to be more on the creative. So books, movies, televisions, video clips, sculptures, paintings, those type of things. Those are going to be in the copyrights. Where I would start with the company is I would look and say, where is the core value of your business and what are you protecting? So if you're the next Starbucks, right? Starbucks does coffee, they do donuts, they do drinks and whatnot. They don't probably have very many, if anything, proprietary. Their coffee, isn't that much different than everybody else's, although they're good branding. But they have a very strong brand. So to them, a trademark is very important because it's all tied up in their brand. You think of Pepsi, Coke, not getting political, Donald Trump and Trump Enterprises, all of those are different brands, and a lot of their value is tied up in their brands, and it's because that's what everybody associates with it. Alternatively, let's say so if you're a software company and if you're an app company, maybe you just made the next dating app, and there's really nothing different about it other than it's a great brand, whichever brand it is. And I never use dating apps, so I'm not a good one to do that. But it's a really good brand, catchy, people like it, and you're a great marketer and great salesman. Then you're going to want to make sure to protect the brand of it. Alternatively, let's say you make the world's best software application that's going to change the world. It's going to have, it's going to cure cancer. It's going to tell you how to, do whatever, and it has a lot of functional utility to it. You're going to want to protect it with a patent, in the sense that where the value of your business is more on the functional utility, the invention, the software, how it works. And so where I would start is wherever you see the value of your company, wherever wherever the core value of your company is, that's where you start to build your protection around, and then you can expand out from there. But that's always where you'd want to start.
Nice. Yeah, and I've actually done one of each many times before. I own a couple copyrights, trademarks, and I did some provisional patents. Now, in terms of the patents, the part where you said that you want to protect the software that you built because you want to change the world with some new platform, right? But isn't it true that it's not only difficult to patent a platform because a lot of it is either open source technology that is either already patented, or if you build something, let's say, for example, you build like a blockchain enabled legal platform where you input some stuff and then it spits out a contract for you, right? And it puts it into a smart contract. Like that probably already exists, but let's just say it doesn't. Can't somebody come along, see your patent on Google Patents or on the uspto.gov website and see the patent and say, oh, well, I see what they did here, but I can just change this little thing here and now it's a different patent. Isn't that like...
Yeah, yes and no. So I would say, first of all, let's define what the purpose of a patent, because there's a few different purposes of a patent. One is to box out other people from doing what you're doing. That would be one thing. Another is I would look at it as an asset of the business, right? So it can be, it's a lot of times you put in a lot of time, blood, sweat, and tears into a company and you put, figure out how things work and how things function. And it's hard to monetize that. A patent is something that you can have, something that investors are investable. It can be an asset of the company you can borrow against, or other things. You can license it out. If you're getting acquired, it can be an asset that gives you a valuation. So it depends a little bit on what what the purpose of your patent is. It's not only just to box people out, but can it serve other things?
But I mean, what about the fact that there's, I don't know how many thousands or maybe even more than that of these people, what they call patent trolls, who just patent stuff and they don't ever do anything with it. They just patent it. They don't do anything with it. They just sit on it. And then when companies come out with their idea, they sue them. And like, how is that even fair? How is that legal? Like, why are they allowed to do this? Shouldn't you have to have proof that you are building something or you built something and you patent it? Because that just doesn't make any sense to me. I never understood that.
Well, let's go back to your, let me answer both of your questions, or maybe, and take a whack at that. So the first thing is, is if you're doing software, but any patent, could somebody design around your patent? I would say anybody with enough time, money, and effort could always design around a patent. But that's kind of a little bit aside from what it is. Typically, I would say a patent, I would relate it to a minefield. What you're trying to do is make a minefield that it's so difficult to get around. You can get around all the mines, but it takes so much time, money, and effort that it's easier to know the path. And so you're going to go get a license from them, acquire them, or otherwise do that business than it is to design around. Meaning, yes, I can design around your patent. If it's going to take me 5 times as much money, twice as long, it's going to be twice as expensive, less efficient, then yes, I can design around it, but it may not be worthwhile. So that's kind of one thing I'd look at, is you're typically building a portfolio of patents that creates a bit of that minefield, such that it's, yes, people can design around, but it's so difficult and so less worthwhile, you either discourage them or they're going to come to you in order to go forward.
So you think the more specific your patent is, the better?
I think that there's a balance between, if you go so narrow that it only covers your exact invention and it's very easy to design around, then your minefield is crappy, right? It means you put one minefield in a big field, and they the chances they're going to hit into it is nil. On the other hand, if you try and go so broad that you never can get a patent, you're never going to build your minefield. So there's a bit of a middle ground to where you're trying to get a reasonable scope, reasonable breadth of your patent, such that it gives you enough to cover what you're doing and cover likely design around, but you're not going to be mired in forever trying to get too broad of a patent. Now, the second question you asked, and I'd almost tag on the patent trolls. Patent trolls, I'll defend them both ways. One sense, there are some horrible patent trolls out there that they've just built a business around going and making or exacting money from particularly small businesses that can't afford to go into a lawsuit, and they're saying it's easier to just pay them off than it is to fight them. Even if I'm in the right, even if the startup is completely fine, they get sued and says it's easier to just do a payoff. I'll give the defense of the patent trolls is that sometimes, let's say you're a startup or a small business, right? And you put in a ton of time, money, and effort to develop the next world's best next widget, the next iPhone that's going to blow the iPhone out of the water. But you're still a startup, and you can't compete with the big boys. You can't compete with Apple or Samsung. If they want to come along and squash you, they could, because they just have money to bleed you out. Sometimes in that situation, a patent troll, or a good patent troll, if you want to call it that, you can go and they're in the business of enforcing it, of having that resources to take on the bigger companies, because that's their business model. And so you may partner up with, either sell them, license, or otherwise take an agreement, such that while you can't fight those battles, the patent trolls can on your behalf. And so there is a small subsection of patent trolls that may be beneficial, in the sense if they're actually going out and trying to help the startups or small businesses to enforce it. Now, the ones that go and gobble up a whole bunch of patents and just try and make everybody's life miserable, I'm not defending them at all.
Yeah, I was going to say that those are the ones I'm talking about. They're the ones that literally, they spend their time and money just getting patents and then looking for companies that are putting out their ideas and just targeting them with lawsuits. I think that it almost is stifling innovation in a way, because in the news you read about it, where these companies are coming out with ideas, but like, oh, wait a minute, there's a patent on it and the guy didn't build anything, but now he's suing us for all the money we have, so we have to shut the company down. Well, there goes one company shut down because they can't. So, but it makes sense. I like your take on battling Goliath, basically. So these little Davids are out there trying to beat down Goliath, and and the funny thing is, I think the large corporations don't really care, because they have trillions of dollars. And so for them, paying off patent trolls, they're here's your money. Here you go. You know what I mean?
It depends. It depends on if the patent troll is going to cave, right? Let's say, as an example, and I said these are probably tangential because majority of patent trolls, I'm not defending them, so don't take that away. But let's say you really do have a valuable patent. You're saying Apple is infringing our patent. If we go through all the course, we have a much bigger payoff at the end of the road than we do by taking the little amount that's for settling. They may go up the full distance because if they settle, they may get $100,000. If they take it the whole way, they may get $100 million. They're going to do that cost best analysis, risk analysis, saying this is worthwhile to take it the whole way because we really do have a strong patent and they really are infringing it. So it kind of, I'm sure that, patent trolls are going to look at it and say, do we take the quick money now, or do we really have a winner of a case that we really do think that we can go after them? And in that case, they're going to see it through and not just walk away.
Makes sense. And speaking of money, right? This is one of the biggest questions I get asked from entrepreneurs usually is the difference between not only equity and stock options. Most of them don't understand the difference, but also how to determine how much equity to give to a co-founder or an employee, how many stock options to give an employee or a co-founder or an employee, when to give it to them, and why a cap table is important, things like that.
Yeah, I mean, and putting aside, stocks, I would say stock and equity are a little bit the same in the sense that you're really giving up a portion of your company. And that can either be via stocks, and it's a certificate. If you're a C Corp, S Corp, those type of things, you'll probably issue it as a stock. And so you have so much stock, which equates into how much ownership. Equity is just straight, this is your percentage of ownership. So really, I just treat them, for most people, as it's just giving up a portion of your company in different forms. Now, how much you give up, I mean, that is always the question, and it's always a hard one to do. And I've done several startups myself. Most of the time, I tend to be more of, hey, if I can bootstrap it, if I can do it myself, I'd rather keep it to myself. But there are companies that I've done that it's just simply too expensive I don't have the resources to launch the idea, and such that if I keep it to myself, the company's just never going to go anywhere because I can't bootstrap it, because they were technology companies. They had a long development path. They required a lot of expense in order to get there. You had to take on people that had bigger checkbooks than I did personally. And then that one's always a battle of, you're trying to push it as far as you can, get as far as along down the road, such that you had to give up the smallest amount of equity while not going bankrupt or going under because you didn't have enough. And so I don't know that I have a good rule of thumb, other than I try and take as little amount of money as late as possible until I need it, and that's usually the best rule of thumb. But you do have to be careful that if you wait too long, you can either one, miss the window, or two, go bankrupt because you never made it, because you ran out of money halfway through, and now the investors aren't going to come in because you're in a downward trajectory. You're not looking like you're doing well, and you're scrambling type of a thing. So other than my general rule of thumb is wait as long as you can and take as little as money as you can. That's probably as good of advice as I can give.
Normally, when it comes to startups, I've run quite a few. I always equate stock options with employees, interns, and things like that, and then equity I equate with my co-founders, people who I started the business with. And then my rule of thumb is usually how much money would they have earned at a similar job. And then I try to value the company or the business, and then I look at the percentage of how much of that would have been their income. So I actually do math. When I try to get very specific.
Sure.
The second piece to that I usually do is how much time are they going to give the business? Can they be full-time, or can they only be part-time? So if it's part-time, then I say, okay, well, that means you would only earn half of your salary at this business, and that's this percentage. So I really do it by like time and by how valuable they are, like how much they would earn somewhere.
And then the only caveat I would give to people, and you'd probably agree, is you have to be careful. It's always easy at the beginning to just give out stock or equity as candy. It's almost, hey, I can't pay you, but I'll give you a whole bunch of stock. And then you slowly, death by a thousand cuts, you slowly give away so much that one day you wake up and you're saying, I don't own anything. I've owned 5% of my own company, such that I'm not motivated. I don't want to work here. I'm going to go do something new again because I can't do it. And you kind of get in that bad cycle because, every employee you give a small stock option, it's just a small bit, but they start to add up because you're giving away stock, you're giving giving away equity over time, such that you become to be no longer enticed on your own company.
Well, you believe in vesting, right? So like a 4-year vesting period where like you have to earn it over time, or 2-year vesting. Sometimes you can give them like a little bonus to start and then earn the rest. That's really what people need to do, right? The whole vesting period.
No, absolutely. And I would, other than maybe a very small bonus at the beginning, most of it I would say you'd want to be a vesting period. And vesting period is basically they either have to stay at the company so long, or they have to hit so many milestones or do so much or put in so much of their own money. But you can make it different ways, but they have to have basically goals or milestones such that if they don't reach that, they don't stay with the company long enough, they don't meet their performance goals, they don't get that equity. And I would absolutely put that in, because otherwise what you're going to do is you're going to give it out front. They're going to take it for granted. They're not going to remember that it was that this was a bonus. It was supposed to be out over time. And then you get people that are frustrated and you're continually battling it. So I'm in complete agreement with you.
Awesome. All right. So to wrap things up, I want to ask you one last question. If you could tell every entrepreneur out there what the biggest mistake that most people make when it comes to legalities or law, when it comes to starting a business, what is it and how can they avoid it?
All right, and I'll give a self plug in a second, but I'll give the real answers to whether or not you come to me or not, which is, most of the time your startups and small businesses are scared to go to an attorney because they're going to say, I don't even know if I need an attorney, and I don't want that dollar sign, hear the ka-ching, the cash register going in, that as soon as I go in, I'm going to start spending hundreds of dollars, only for them to tell me I don't need, they can't help me, or I'm too early or whatever. And so what I would say that's the typical mindset. I would probably flip that. Usually I would go to an attorney earlier, in the sense that they may be right. They may tell you you're too early, but they'll usually, if you get a good attorney, they'll give you a roadmap of, hey, this is when you should engage us. You may want to come to us 6 months or a year down the road. These are the things that you'll want to consider. I would, and they'll give you a bit of that strategy or that pathway, at least if they're a good attorney. There are plenty of attorneys that won't, but you're going to want to find one of those that are. The other one I would do is, as you're doing that, a lot of attorneys, myself included, and there are others, they'll do it like a strategy session or a free consultation, such that you can go in, at least ask your questions, get an idea, get a roadmap, and figure out when you would want to engage them. And they'll oftentimes do that without charging anything. And that's kind of where I'd find that good mix of finding an attorney, going in early, finding one that will spend a few minutes, lay out a strategy with you, help you understand when you should do things, why you should be doing things, not just telling you to do things, but explaining it along the way, and then in helping you to set out that path. But the biggest mistake is I always see the end of people wait so long that they miss their windows. I get the people that are coming in and I've got a great idea and I want to get it patented. I've only been out in the marketplace for 3 years, and I'm thinking, then I have to tell them, well, that's great that you have a great product. I'm excited for you. I hope your business does well. But problem is after it's been out in the public for a year, you can't file a patent on it and we can't help you. And so that's a lot of times they miss, because they're so scared to go talk with an attorney, they miss the windows that they don't know about, and it creates more expensive and issues if they can even be remedied down the road. Now, my self-interested plug that if people do want to do a strategy session with me or somebody else, but if they wanted to come to us, they can just go to strategymeeting.com. They can sign up right on my calendar. We'll sit down for 30 minutes. We'll talk through their company. I'll give them advice as if I was in their shoes, what I would do, what I would think about. I try and also offer not just the legal perspective, but the business perspective, because I think that's a lot of times you go into an attorney and they'll give you great legal advice and they'll give you horrible business advice because they've never done a startup, never done a small business. They have no idea how they really work in reality. And so, I always try and mix that where I've done both on both sides.
That's really important. That's really important because one of my first startups was with a guy who didn't know anything about business or technology. And his crutch was, let's go to a lawyer. And he's like, I don't want to do it. And I had to, because it was either doing that with him or not doing the company at all. And at the time, it was really early in my startup career. So I kind of thought like, okay, maybe this is a good idea. But dude, you're right. It was all about the legal stuff and not about the business itself. And so I always tell people, look, when you're going to build a business and go to a lawyer, make sure you have something substantial to take to a lawyer first. Like do the groundwork first, because if you go to the lawyer and they start dictating to you what to do, you're doing it backwards.
Yeah, no, absolutely. And I always joke, but I think there's a lot of truth to it. Lawyers give great legal advice. They give horrible business advice. So don't go to an attorney for business advice. Run your own business. Now, I said, I'll put myself as an exception because I've grown several startups. I've done 7 and 8 figure businesses. And so I've split my attention, but split my efforts between startups and small businesses and the legal field. So I'm probably a bit of an exception. But generally, if you're going into an attorney for business advice, to your point, you've got it flipped backwards.
That's awesome. That's great. It's great that you've done both, so you can give some really good, helpful information to people when they come to you. So strategymeeting.com, and you have a website for your law business.
Yeah, so strategymeeting.com, that will actually link to the website, but it's primarily for a calendar to sign up. If you want to just find out more about the law firm in general, find out more about our prices, information, learn some stuff, just go to lawwithmiller, all one word.com, and then they can find out more about the firm, myself, everything and all about it.
Awesome. Thanks again for coming to the podcast, Devin. I appreciate it.
Hey, it was a pleasure. It was fun to chat a bit about business and IP with you.
Yeah, hopefully we made legal a little bit more interesting for people to listen to.
That's right. As interesting as law and attorneys can be.
Awesome.